This is an interview with Jose Silva Jr. Jose is an attorney in Vineland, New Jersey, and has been practicing law for over 25 years. He is a member of the New Jersey and Pennsylvania bars, and some of his areas of practice include estate planning, elder law, real estate law, contracts, business transactions, healthcare law, and criminal defense. We'll talk about three of the most basic legal documents: wills, powers of attorney, and healthcare directives. We cover a lot of ground in this interview, so I'll break it down into 4 parts.
Hello and welcome to The Art of Money Mastery, brought to you by Harbour Master Diversified Financial Services. This show will simplify your life and guide you along your financial journey by making your personal finances easy to understand so you can make better decisions with your money.
So let's start from square one. Why do people even need to create a will? And what happens if somebody doesn't have a will?
In today's day and age, it's advisable that everyone have a will for a variety of reasons. Some people will say, I don't need a will because I don't have anything to leave. And they might be correct in saying that they have nothing to leave, but they might have a minor child. Or they may have a situation with a minor child where they want to have someone be the trustee and someone be the custodian. So there's always a need for someone to have a will, because if you don't, then the court will appoint someone. And that's where the battle begins, when someone who you never thought potentially of being your executor is now named as your administrator, and they are the ones in charge of administering your quote-unquote estate.
Okay, so if somebody's getting ready to meet with an attorney to prepare a will, what are some of the things they should know ahead of time?
Before they come to an attorney, they should put together documents, such as if they own a real estate, they can own vacation homes, they can own timeshares. Have a portfolio ready to give to the attorney of all those assets. You want to be able to show the attorney all those items, because you might say, I want to leave my son my house that's in Pennsylvania, but you have no address, you have no location. So you want to be able to at least put some type of information so that individuals know where this property is located. Or if you have assets such as a pension, you want to give them as much information, and you want to be able to make sure that if there is a situation where you're over the threshold for the tax exemption, that the attorney does the proper planning. It might be a situation where he might want to do what's called generation skipping, or some other type of planning to avoid, for example, in New Jersey, that tax exemption. You want to be under it. You don't want to be over it, otherwise you pay taxes. Places like Florida have no exemption. It's okay to die there because it's free. Not like New Jersey and other states where you're going to pay out through your ears.
So you mentioned executors earlier. What exactly is an executor?
Well, there are individuals that you are going to give a certain amount of authority or power that you are delegating once you have died. People understand a will is not a living will. People usually come to me and say, I want to do a living will so that when I die, and I have to stop them and say, well, there's 3 documents, potentially 4 or 5, but the 3 common documents are your power of attorney, your healthcare directive with your healthcare directive instruction, and your will. So I usually work backwards, and I start with the power of attorney, your healthcare directive, and then your will, because your will is something that happens when you die. Once you have died, the will takes effect, and it tells the world what your intentions are with regard to your assets or your children. The executor, for example, is the person who is primarily responsible for handling the entire estate, payment of bills, taxes, all of those things would be the executor's responsibility. So if there are taxes that are payable to the state of New Jersey, or bills that are payable to any debts that are owed to any creditors, the executor would be responsible for doing that. There are other individuals, for example, who's going to be the trustee for a trust, who is going to be the custodian for the children. And what I try to have clients do is give me the main character. Who is going to be the main executor? Don't give me your 96-year-old mother to be the executor and you're 50 years old, because chances are she will not outlive you. Try to give me someone that is in your age group or younger, that you have enough respect to know that they will be responsible to handle your affairs once you die. I also instruct clients to give me more than one individual, what I call the contingent executor. So let's assume you name Phil Fratto as your executor, but you also put in 2 or 3 other people as alternate executors. So the will say, I appoint Phil Fratto. However, if he's unable or incapable of carrying out the function, I then appoint, and you put someone else. And then you put 1 or 2 other people in case those individuals can't do it. I mean, you might appoint someone to be your executor and they are on their honeymoon and something happens to you and they're away 2 weeks on a cruise. There's no way they can do anything, and things have to get done immediately. Although it would take the surrogate's office about 10 days to get things done, you still need to get the death certificate to them. You need to start filling out paperwork. So it's up in limbo. So if that individual cannot do it, you want to have someone else, in the batter's deck, ready to take over in case something happens.
So, what would you say are some of the most common mistakes people make when they prepare a will?
One of them is they appoint someone that they either don't trust. The common mistake that I see is I'll have a client come to me and say, I don't really trust my sister because she's stolen from me X number of dollars. Well, how about someone else? Well, I don't trust them either, but they're not family. So they either appoint someone they have no trust for, or they appoint someone who doesn't really know them, or someone who is much older and will not outlive them. Other common mistakes are, and this, I just went through this, where husband and wife prepared an estate plan and they named individuals who are in other countries to be the custodian for the kids and the trustees. So imagine someone who lives in New Jersey and they appoint someone in Peru or in Italy to be the executor. It doesn't make any sense, especially if they don't have a visa to come here, they've never been here, or they don't speak the language. So it becomes a lot more of a horrifying experience for that individual, and they just can't carry out the function.
The content provided herein in writing, audio, or by video is for informational and educational purposes. The content is not intended as legal advice to the individuals reading, listening, and/or viewing any of the content herein. Each case is different, and as such, by accepting to view, listen, and/or view the content, no attorney-client relationship has been established between Jose Silva Jr. and his law office of Jose Silva Jr. Attorney at Law, LLC. Furthermore, the information here is a marketing tool and advertisement by Jose Silva Jr. Attorney at Law, LLC, and its employees, agents, and representatives. Should you have any questions regarding the content herein and wish a consultation with Jose Silva Jr. Attorney at Law, LLC, you must set an appointment for a consultation and pay the required consult fee. At that time, further and perhaps more specific information may be provided as it pertains specifically to individual cases.
Securities and insurance services offered through Royal Alliance Associates, Inc., member FINRA SIPC. Insurance services may also be offered through Harbour Master Diversified Financial Services, Inc. Advisory services offered through Investment Advisors Asset Management LLC, a registered investment advisor. Royal Alliance Associates, Inc. is not affiliated with either entity.